March 15th, 2025. A federal judge in Washington, D.C. gets an emergency hearing called on short notice. Planes are in the air, carrying more than 100 Venezuelan men to a foreign prison under a wartime law that hadn't been used in decades. The judge orders the planes turned around. Right now, on the record, from the bench, the planes don't turn around. They land in El Salvador. The men are handed over to a mega prison known as CECOT. A year later, that same judge, the chief judge of the entire federal court in Washington, has found something extraordinary. Probable cause to believe the government committed criminal contempt of his own order. Not a policy disagreement, not a legal gray area. Criminal contempt. The accusation that the executive branch of the United States government defied a direct federal court order and did it anyway. And then, on April 14th, 2026, an appeals court stepped in and shut the entire inquiry down. Not narrowed it, not delayed it, ended it permanently in a 2-1 ruling. The dissenting judge on that panel didn't hold back. She wrote nearly 80 pages explaining why she thought her colleagues had just gutted the ability of any American court to hold any future administration accountable for ignoring its orders. Her exact words, "Contempt of court is a public offense, and the fate of our democratic republic will depend on whether we treat it as such." That's not commentary from a critic outside the system. That's a sitting federal appellate judge writing in an official legal opinion about what just happened inside her own court. So here's the real question this story raises, and it's bigger than one judge, one ruling, or one deportation flight. If a federal court order can be defied and the defiant still can't be punished, what does a court order actually mean anymore? Here's the headline, stated plainly. On April 14th, 2026, a divided panel of the U.S. Court of Appeals for the D.C. Circuit ordered Chief U.S. District Judge James Boasberg to fully terminate his year-long criminal contempt investigation into senior Trump administration officials, ruling 2-1 that the inquiry itself was a clear abuse of discretion. The underlying dispute traces back to March 2025, when Boasberg ordered deportation flights carrying Venezuelan migrants under the Alien Enemies Act to turn around mid-flight. The flights landed anyway. More than 130 men were transferred into custody at El Salvador's CECOT prison. Boasberg later found probable cause to believe the administration had committed criminal contempt of his order, a finding serious enough to trigger sworn testimony, subpoenas, and a formal investigative process that stretched on for roughly a year. The Justice Department fought that inquiry at every stage, appealing repeatedly to stall it. This April, a 3-judge panel, split 2-1 along the lines of who appointed them, sided with the administration, and ordered the entire investigation shut down for good. Circuit judges Naomi Rao and Justin Walker, both nominated by President Trump, formed the majority. Judge J. Michelle Childs, nominated by President Biden, dissented, sharply and at length. The Justice Department called it a win against what one official described as a year-long campaign. The ACLU's lead attorney on the case called the ruling a blow to the rule of law. Both of those reactions are on the record. To understand which one holds up, you need to understand exactly what happened on the day this all started. Here's what you need to know coming in cold. James Boasberg is the chief judge of the U.S. District Court for the District of Columbia, appointed by President Obama. He's not a political outsider. He's the senior-most trial judge in the federal court that handles the bulk of legal challenges to executive branch action in Washington. The case traces back to the Alien Enemies Act, a law passed in 1798, rarely invoked in modern American history, that grants the president extraordinary wartime removal powers over foreign nationals from countries the U.S. considers hostile. In March 2025, the Trump administration invoked it to justify deporting more than 130 Venezuelan men the government alleged were members of the gang Tren de Aragua, flying them directly to El Salvador's CECOT, a maximum security terrorism confinement center built specifically to hold accused gang members, where they were ultimately held for months. Before those flights landed, lawyers challenging the deportations got an emergency hearing in front of Boasberg. He ordered the flights turned around, both verbally from the bench and in a written order issued shortly afterward. The government did not turn the planes around. The men were transferred to Salvadoran custody. This is where it stopped being a normal immigration case and became a constitutional flashpoint. Boasberg didn't just criticize the administration's decision. He opened a formal criminal contempt inquiry, the most serious tool a federal judge has for punishing defiance of a direct court order. President Trump responded by publicly calling for Boasberg's impeachment. In an unusual public statement, Supreme Court Chief Justice John Roberts rejected that call directly. That's the environment this entire fight has played out in for over a year. A sitting judge investigating potential criminal contempt against senior officials of a sitting president, a president publicly demanding that judge's removal, and the nation's top judicial officer stepping in public to say that's not how this works. Now let's walk through exactly how this played out month by month. Here's the full arc, beat by beat. March 15th, 2025. A hastily called emergency hearing takes place in Boasberg's courtroom as deportation flights are actively underway. From the bench, Boasberg orders officials to turn around and return to the United States any active flights carrying the Venezuelan men. Less than an hour later, he issues a written order, but this one is worded more narrowly, barring only the removal of immigrants currently in the U.S. The flights land in El Salvador regardless. More than 130 men are transferred into custody at CECOT. In the following weeks, Boasberg begins pressing the administration for answers about why his order wasn't followed. He orders then DHS Secretary Kristi Noem to explain her role in the decision. Her declaration, in Boasberg's own words, does not provide enough information for the court to determine whether her decision was a willful violation of the court's order. Later in 2025, Boasberg escalates, seeking live sworn testimony. First from Erez Rovini, a former Justice Department attorney who had separately filed a whistleblower complaint alleging a top DOJ official told colleagues in March that the administration intended to ignore court orders. Boasberg also seeks testimony from Drew Ensign, a DOJ official directly involved in the March 15th hearing, who the department later acknowledged had promptly conveyed Boasberg's orders up the chain to DHS and DOJ leadership. Throughout 2025, Boasberg finds probable cause to believe the government committed criminal contempt of his order. The Justice Department appeals to the D.C. Circuit, not once, but repeatedly, each time attempting to halt the contempt proceedings before they can move forward. The case stalls for much of the year under the weight of these appeals. February 2026. With the case still tied up, reporting confirms that of 91 men from the CECOT deportation who'd been reached by their legal team, only one had said he would not challenge his designation, while dozens more sought to pursue habeas corpus petitions or return flights, underscoring that the underlying human stakes of this case were still very much unresolved, even as the contempt fight dragged on. April 14th, 2026. In a 2-1 ruling, D.C. Circuit Judges Naomi Rao and Justin Walker order Boasberg to fully terminate the contempt inquiry, calling it a clear abuse of discretion that improperly threatened an open-ended, freewheeling inquiry into executive branch decision-making. Judge Childs dissents at length, arguing the majority effectively rewrote the law of criminal contempt to protect the government from ever being held to it. Same day, Acting Attorney General Todd Blanche publicly celebrates the ruling. A CLU attorney, Lee Gellert, calls it a blow to the rule of law and confirms plans to seek review from the full D.C. Circuit. That's how a year-long fight over a single order ended, not with a resolution of what happened on those flights, but with a ruling about whether the question could even keep being asked. And the reasoning behind that ruling is where this story gets its sharpest edge. Here's the contrast that decided this entire case. And it comes down to 9 words spoken from a bench versus the written order that followed less than an hour later. From the bench on March 15th, Boasberg told government attorneys to turn around and return to the United States any active deportation flights. That's about as direct as a judicial order gets. But when Boasberg's formal written order followed, issued less than an hour after the hearing ended, its language was narrower. It barred the removal of individuals currently in the U.S. It didn't explicitly address planes already in the air or explicitly prohibit transferring the men into Salvadoran custody once they'd landed. That gap between what Boasberg said out loud and what his written order actually specified became the entire legal foundation for the majority's ruling. Judge Rao, writing for herself, and Judge Walker put it directly: criminal contempt is available only for the violation of an order that is clear and specific, and Boasberg's order did not clearly and specifically bar the government from transferring plaintiffs into Salvadoran custody. In the majority's view, because the written order technically left that door open, the government's actions, however much they defied the spirit of the bench ruling, couldn't support a criminal contempt finding as a matter of law. Now, here's the other side of that same set of facts from Judge Child's dissent, nearly 80 pages, and unambiguous in its conclusion. She argued her colleagues had gone further than simply reviewing one order's wording. They had, in her words, decided as a matter of law that the government just cannot have committed contempt, cutting off Boasberg's fact-finding process before it could even run its course. She warned this sets a new precedent. Now, any litigant can argue, based on their preferred interpretation of a court's order, that they did not commit contempt before contempt findings are even made. And ACLU attorney Lee Gallant, representing the deported men, framed the human reality behind the legal technicality bluntly. Our system is built on the executive branch, including the president, respecting court orders. In this case, there is no longer any question that the Trump administration willfully violated the court's order. His conclusion, the opinion is a blow to the rule of law. There's a piece of independent evidence that sits uneasily alongside the majority's ruling, too, from whistleblower Erez Ruvini, the former DOJ attorney whose testimony Boasberg had specifically wanted to hear. Ruvini released texts he'd exchanged with another DOJ lawyer, in which they discussed their view that DOJ official Drew Ensign had not been fully candid with the court about whether flights were imminent, even though DOJ had separately confirmed that Ensign personally relayed Boasberg's order up the chain to DHS and DOJ leadership. That's not proof of a specific crime, but it's a document trail suggesting the people executing the government's response knew exactly what the court had ordered. In real time, as it was happening, the exact question Boasberg wanted formal testimony to resolve, and the exact question the appeals court ruled he could no longer investigate. So the contrast at the heart of this case isn't really about whether the flights violated the spirit of Boasberg's order. Even the majority doesn't dispute that something went wrong. It's about whether an order has to be worded with total, unambiguous precision to ever be enforceable, and whether that legal standard once set protects every future administration the same way it just protected this one. Here's where the stakes climb past this one case entirely, because the majority didn't just close Boasberg's investigation. They articulated a legal standard that Judge Childs warns will apply to every contempt case that comes after it, against any administration of any party. Look again at Childs' central warning. Now, any litigant can argue, based on their preferred interpretation of a court's order, that they did not commit contempt before contempt findings are even made. Read that again slowly. She's not just saying Boasberg was wrong to pursue this specific inquiry. She's saying the majority created a new escape hatch, that a party accused of violating a court order can now argue, before any facts are even gathered, that their own interpretation of the order's wording makes contempt legally impossible. That flips the normal sequence of contempt proceedings, where a court typically investigates first and rules on legal sufficiency second. Rao's opinion adds another layer that raises the stakes further. She grounded part of her reasoning in separation of powers concerns, writing that Boasberg's proposed hearings would create an open-ended, freewheeling inquiry into executive branch decision-making on matters of national security that implicate ongoing military and diplomatic initiatives. That's a significant expansion of judicial deference, not just to this specific deportation decision, but to a broader category of executive action described as touching national security, a description that could arguably apply to a wide range of future government conduct a court might otherwise want to scrutinize. And this wasn't even the first time the D.C. Circuit stepped in to block Boasberg on this exact matter. Months earlier, Circuit Judge Gregory Katsas, another Trump appointee, had already ruled that Boasberg's original bench order was insufficiently clear to support a contempt inquiry over the plane's turning around. That earlier ruling forced Boasberg to narrow his focus specifically to the custody transfer question, the exact question this April ruling then also closed off. Two separate rulings, months apart, both from Trump-appointed judges, each time narrowing what Boasberg was allowed to even investigate, until there was nothing left to investigate at all. Meanwhile, this was unfolding against a backdrop of open political hostility toward Boasberg personally. Trump publicly called for his impeachment, and the Justice Department separately filed a misconduct complaint over Boasberg's public comments about the case. Chief Justice Roberts took the unusual step of publicly rejecting the impeachment calls. That's the environment this contempt inquiry was decided in. A judge facing direct political pressure from the president whose officials he was investigating, ultimately overruled by two judges appointed by that same president. None of that proves the ruling was wrong on the law. But it's the kind of pattern that raises a legitimate question. Is this a neutral legal standard being applied even-handedly, or a standard that happens to consistently favor the administration whose officials are under investigation? That question deserves a fair hearing of the other side's actual argument, not a dismissal. The majority's legal reasoning deserves to be taken seriously on its own terms because it rests on real, long-standing principles of contempt law and separation of powers, not manufactured technicalities. Criminal contempt has always required a genuinely clear and specific order. This isn't a standard Rao and Walker invented for this case. Courts have long recognized that criminally punishing someone for violating an order requires that the order itself leave no real room for interpretation, precisely because criminal contempt carries the weight of a criminal conviction. If Boasberg's bench statement and his written order genuinely diverged, one broader, one narrower, that's a legitimate legal problem for a criminal contempt case specifically, even if it wouldn't necessarily be a problem for, say, a civil enforcement action or a political accountability question. The government's position, as praised publicly by Acting Attorney General Todd Blanche, was that this amounted to a year-long campaign against Justice Department attorneys who Blanche said were simply doing their jobs fighting illegal immigration. That's a real argument being made by real officials, not a straw man. DOJ has consistently maintained throughout this litigation that its personnel were executing lawful immigration enforcement under a presidential authority tier, the Alien Enemies Act tier, that has not itself been struck down, and that the specific mechanics of the March 15th order left genuine ambiguity about what was and wasn't prohibited. Rao's separation of powers concern also reflects a real and long-standing legal principle, not a new invention. American courts have historically been cautious about deeply probing executive branch decision-making on matters touching foreign affairs and national security, out of respect for the constitutional design that gives the executive branch primary authority in those areas. Whether CECOT deportations under the Alien Enemies Act genuinely qualify as that kind of sensitive national security decision is a fair point of dispute. But the underlying doctrine of judicial restraint in that space is well established, not something Rao manufactured for this case. It's also worth noting plainly, this was a 2-to-1 ruling, not a unanimous one, and Child's dissent, while forceful, represents one judge's reading against two others. The ACLU has said it will seek review from the full D.C. Circuit, meaning this legal question is not settled law yet. It's one panel's interpretation, subject to further appellate review, potentially all the way to the Supreme Court. None of this resolves whether the men aboard those flights should have been turned around or whether the administration acted in good faith on March 15th. But the honest framing is that two federal appellate judges reached this conclusion applying real pre-existing legal doctrine, not that they invented a shield from nothing. Whether that doctrine applied here produces a just result is exactly the question the en banc court and possibly the Supreme Court may still have to answer. Here's why this case matters, even if you have zero connection to immigration policy or the Alien Enemies Act specifically. Every court order, a custody arrangement, a restraining order, a business injunction, a regulatory compliance order, depends on the same basic premise, that if you violate it, there's a real mechanism to hold you accountable. Criminal contempt is that mechanism's sharpest tool. This case just narrowed how sharp that tool can be, specifically when the party being investigated is the federal government itself. Judge Child's warning is the part worth sitting with longest. This ruling doesn't just protect the officials involved in this specific case. It establishes an argument any future litigant, private citizen, corporation, or government official could try to use that ambiguity in an order's precise wording can shut down a contempt investigation before any facts are even examined. If that becomes the operating standard, orders will need to be written with a level of exhaustive, airtight precision that's genuinely difficult to achieve in a fast-moving emergency hearing. Exactly the kind of hearing Boasberg was holding on March 15th, with planes actively in the air. That has real implications for how much practical power any federal judge has to stop government action in real time in future emergencies, regardless of which political party holds the executive branch. If the lesson courts take from this ruling is that emergency bench orders need to be worded like carefully negotiated contracts to survive a later contempt challenge, that changes how much protection an emergency court order can actually offer anyone, not just deportees on a 2025 flight, but any person or group depending on fast judicial intervention in a fast-moving situation in any future administration. That's the through line connecting this case to your own life, even indirectly. The strength of a court order is only as real as the consequences for ignoring it. This ruling is a live data point on how strong or fragile that consequence actually is right now in the current federal court system, and it's still being contested. So here's where this actually stands. This 2-to-1 panel ruling is not necessarily the final word. A CLU attorney, Legal Alert, confirmed the legal team representing the deported men plans to ask the full D.C. Circuit by sitting en banc, meaning the entire bench of appellate judges rather than just the 3-judge panel, to review this decision. Verify current status of that en banc petition before publishing, as timing may have moved since this April ruling. If the full circuit takes up the case, every judge on the D.C. Circuit could weigh in. Not just the 3 who already ruled, 2 of whom were appointed by the president whose officials are under investigation. That's a meaningfully different bench than the one that just decided this case, and it's not a foregone conclusion which way a larger, more ideologically mixed panel would rule. And there's a bigger question sitting one level above even that. If the en banc court doesn't reverse this panel, does this case eventually reach the Supreme Court? The same court whose Chief Justice already took the unusual step of publicly pushing back on calls to impeach the very judge whose contempt inquiry just got shut down. Would the court address the underlying question Childs raised in her dissent, whether any litigant, including any future president of either party, can now use ambiguous order wording as a shield against contempt before the facts are even examined? None of that is resolved yet. What we do know is this: over 130 men were flown to a foreign mega prison in defiance of a judge's bench order. A year-long investigation into whether that defiance was criminal has now been formally shut down. And the legal question of whether that shutdown was correct is still, as of this reporting, working its way through the appellate process. That's not a closed story. It's a story with its next major decision point still ahead, and one that could reshape how enforceable federal court orders are against any future administration, not just this one. If you want the next ruling covered the moment it lands, whether that's an en banc decision or a Supreme Court petition, that's exactly the kind of follow-through this channel exists to deliver. Subscribe and turn on notifications so you're not catching this 3 weeks late after the headline's already lost half its context.